Andy Davis reporting. Well, a little earlier I spoke to the Foreign Secretary, David Miliband. So, Foreign Secretary, Binyam Mohamed was tortured.
He was certainly subject to inhuman treatment. There's a blurred...
No, was he tortured?
Well, torture...
Yes, tortured.
No, torture can be constituted by repeated inhuman treatment. That's something that the court is looking at the moment in his civil case. And as you know, there is a blurred dividing line between inhuman treatment and torture. Both of them are unacceptable to the UK. But whether or not repeated inhuman treatment constitutes torture is something the courts are looking at the moment.
It sounds like hair-splitting, given that the judge in the case in America concluded he had been tortured, and she used the words during the time he was held, and the British government knew, in paragraph 123 of today's judgment, the British government knew of his situation, sanctioned his detention, and she says he was physically and psychologically tortured. You don't agree?
We sanctioned no such thing, and I hope you'll come back to that in the interview, because we've been calling for Guantanamo Bay to be closed for a very long time. We were instrumental in getting him out of Guantanamo.
Do you condemn it then? Do you condemn that he was tortured?
Of course. Well, we condemn the inhuman treatment, and the court in Britain is investigating whether or not it constituted torture.
The suspicion has to be that the reason you suppressed the 7 paragraphs which the court has now released to the general public was because they revealed he'd been tortured, not because in any way they compromised our relationship with America.
That is completely untrue. That is an absolute slur. This government, and myself in particular, were instrumental in getting the documents to Binyam Mohamed's legal counsel so that he could be released from Guantanamo Bay. Far from suppressing the documents, we insisted to the United States...
No, you suppressed the 7 paragraphs. That's the point. And the paragraphs deal with his torture. The paragraphs in the original judgment about which this case was for.
I'm sorry. It's really important that you allow your viewers to hear the answers. What was subjected to Mr. Mohamed is detailed in the documents. The paragraphs are a summary of them. It was thanks to our efforts that Mr. Mohamed got the documents, or his legal counsel did, and that he was then released from Guantanamo Bay.
What may strike people as very curious is that you decided to try to challenge an element of the judgment after the deadline had passed, during which submissions and alterations could be requested.
No, I'm sorry.
4 o'clock on Monday afternoon. Your lawyer did not reach the court with his letter, this is Mr. Sumption, until 6 o'clock that day.
For goodness sake, John, we have followed consistently absolute legal propriety and legal practice. It is a fundamental feature of our system that a draft judgment is submitted both to the government and also to the counsel for Mr. Mohamed. Both sides are within their rights to query issues of fact. That's what the counsel did. The judiciary then have a decision to make about their final judgment. The judgment that's been handed down today is the final opinion of the Court of Appeal.
Everything you say is true, Foreign Secretary.
Oh, good. Well, let's have that. Everything I've said is true. That is an important thing to leave on this.
Everything you say is correct. It is perfectly possible to challenge elements of the judgment, and all barristers in the case could do so. However, your barrister went to the court, did not disclose his letter to the other barristers, as he should have done, until 11 o'clock the next morning, by which time the judges had made their judgment and withdrawn the elements that you complained of.
This is a nonsense conspiracy theory.
That is nobbling the court.
Our barrister submitted in a completely normal way a letter to the 3 of the most eminent judges in the country. They then considered that letter. They had a meeting about it. They discussed it with each other. They discussed whether or not what was in the draft judgment was based on the evidence that had been submitted to them. They concluded that it was right to amend the paragraph. They took responsibility for that. That is full separation of the judiciary from the executive. And it's very, very important that you allow the facts to come out, not the conspiracies to come out.
All that happened.
And all that is true. Admit to me that all that is true.
All that happened before any of the other barristers, including Mr. Binyam Mohamed's barrister in the case, ever had a sighting of your complaints. That judgment was entered before anybody else could see it. It was entered in secret, and that is against the law, Foreign Secretary.
Well, I have seen the letter that was submitted to the court. I noticed at the bottom of it that it was copied to the counsel
only at 11 o'clock the next morning, Foreign Secretary. I've checked this with the barristers concerned.
Right, well, why don't you check it with the counsel who submitted it? Because they submitted
it. So you're blaming the counsel?
No, I'm not blaming anyone. I'm saying that a case has come out and the government has lost. But the court in the process said that the control principle that we were seeking to defend should be upheld. It's also the case that legal propriety was carefully followed and ensured that everything was done to ensure that the judges were able to make their own judgment. If you're saying that the Master of the Rolls, the President of the Queen's Bench Division and the Lord Chief Justice are not able to make up their own minds, that's something that you should take up with them. But I will defend to my dying day the ability of 3 of the most senior judges in the land to make up their own minds. And if you're if you are reduced in desperation to saying, in your word, that those 3 judges have been quote-unquote nobbled, you should be ashamed of yourself.
The issue, Foreign Secretary, is what is actually contained in the letter that the Treasury Solicitor wrote to the judges. And in that letter, he talks about the conclusions the judges had reached, that the security services do, in fact, operate a culture that does not respect human rights and does not abjure the participation in coercive interrogation techniques. That is what they concluded. You managed to change their minds.
No, I'm sorry. They make up their own minds. There is no policy of torture or inhuman treatment or contracting out. There is no policy of seeking to cover up wrongdoing when it is exposed. There is no truth in the allegation that the security services operate without independent oversight. They do. It's happened in this case, and there's a civil case ongoing at the moment.
But your central complaint, Foreign Secretary, was that the judges had concluded that there was a systemic tolerance of this behaviour inside the intelligence services. People, and I don't know, you'll perhaps tell us, how many people inside the intelligence services, inside your own Foreign Office, knew torture was being practiced?
Allow us to, and allow your viewers to know that there's something to defend about our political system. And one of the things to defend about our political system is that we have an independent judiciary. A second thing to defend is that when individuals feel their rights have been abused, there is an independent court to appeal to. And thirdly, when there is wrongdoing, it is investigated. On all of the issues you have raised, alleged wrongdoing by an individual or by a system is being investigated not just by the Attorney General, but by an independent police procedure.
Foreign Secretary David Miliband talking to me earlier.